This is that apartment complex that's in that part of town that the cops don't want to deal with.
It's just a very neglected area in
Area.
every way you can think of.
Yeah. He's actually inside the apartment messaging on his phone, not going outside. He does have a gun, but he doesn't want to go outside. The reason he ends up outside is because his girlfriend, who is only 16, is intoxicated. She believes he's outside. She goes busting out that door. And he follows her out with that pistol. And our client yells out, "Stop, I've got a gun." He yells out, "No talking," and starts coming up the stairwell, knocks her down, and that's when the 2 shots are fired. If this would have taken place in any other part of town, with any other employed white male, and not our client, in the place where this happened, they'd never been in charge. Protection shouldn't just be there for you. It's got to be there for everyone. So we don't just afford this protection to you, John Sisson, or you, police officer, you really great person that doesn't have all these issues. We reserve this for the worst of us. And they can accept that, because at the end of the day, what he did, how do I feel about that? And take away from him. It's
Right.
what he did.
I'm going to steal that from you. I got to use that. It's March 26, 2024. 19-year-old Jonathan Riggins followed his girlfriend down her stairwell that morning with a pistol carrying only 2 rounds. Across from him stood Tyran Williams, 41 years old, furious, convinced Riggins had laid hands on his stepdaughter. Seconds later, 2 shots shattered the dark, one to the chin, one to the shoulder. Williams fell at the base of the stairs, dead before dawn. Within hours, Riggins was sitting in his lawyer's office explaining his story of self-defense. However, within days, he was facing a first-degree murder charge. Today's guests are Brecken Wagner, who's been on the podcast before. What's going on, Brecken?
Thank you. How's it going?
I'm good. And Blake Lynch. Welcome to the podcast.
Yeah, thanks. Glad to be here.
So before we talk a little bit about the case, or in great detail about the case, let's start with you, Blake. Tell us what inspired you to pursue a career in criminal defense, and tell us about your practice and where you practice.
Well, criminal defense was something I stumbled into. Being a lawyer, I had an idea about earlier on. I don't know, I think a lot of kids got to experience going through their parents' divorce, and I did too. And while I was there, I thought, these folks are not making any better arguments than I could. I feel like I could do this. That's that 15-year-old confidence I had. And so I was a debater. My mom was a debate coach, and that kind of translated into a career in the law. And yeah, the criminal defense thing was just dumb luck stumbling into something. 2009, a bad economy. I got a job with a guy who was doing an indigent defense contract, and that was the work I got to do starting off. So.
How about you, Brecken?
My journey is kind of similar. Kind of fell into it. Started in Oklahoma City and wound up as a public defender in Missouri. Then wound myself back to eastern Oklahoma. Ended up on a public defender contract. Eventually started my own firm. In 2013, the 2 of us became law partners, and we have been ever since.
Made it easy. Yeah, the logo was already a W and an L, so it used to be Wagner Law, now it's Wagner Lynch. Worked out easy.
Perfect. So you guys say you fell into it, but I know that's not the full extent of it. You also fell in love with it.
That's true. Yeah.
So
no, we both of us come from a similar background. We're born to parents who were attorneys or knew any. Yeah, we've kind of always focused on the folks that we grew up around and that we had in our lives. So that we find ourselves quite often around poor rural folks, and this case is one of those, actually.
We were definitely not a pedigree couple.
No.
That's for sure. No purebred lawyers in the group. My family's all educators and teachers and farmers, and I think it's fair to say some of them have questions about it. My favorite story about entering criminal defense was I wasn't even an attorney yet. I was a licensed legal intern. I couldn't go to court without an attorney with me. And called me one time to go to a case that was particularly difficult, and then it made the paper. And my grandma the next day called and said, "Is this why we sent you to law school?" I was like, "Well, I mean, kind of. It is part of it." And from then on, just sometimes you get the good draw, sometimes you get a bad draw, and sometimes you can become famous or notorious. Either one works.
See, that really is a recurring theme for people that do what we do. Criminal defense lawyers are really lawyers for the people more than anything else.
Absolutely.
What's a typical day like for you guys?
Not together.
Stop at Casey's on the way to whatever courthouse I'm on that day.
We are road warriors.
Yes. We I remember I got audited a couple years ago because I turned in mileage for how many miles I drove for court, and they didn't believe it. And it just so happened I bought a truck in January and sold it in December. And I was like, I put 43,000 miles on the truck this year driving to court. So we do a lot of time in a lot of places, and I travel all the time. Brecken's on the road quite a bit, and anywhere in Oklahoma we end up at.
That sounds like my partner and I. The past 2 days I had court in New Orleans, which is an hour this way. And then tomorrow I have court in Lake Charles, which is 2 hours the opposite way.
Right.
And I drive a pickup truck, a Sierra, GMC Sierra, but I went out and bought a Honda Accord because I was like, this truck is not made for this.
You don't have to do that. Stick with the Sierra. Just get the electric version. That's what I've got at the house. You plug it up. It's full every day. It goes 400 miles. I mean, it's perfect. And I still get to drive the truck.
I'm concerned about where I would stop if I was running out of juice in Louisiana.
Fine. Just charge it up every night. You'll be set. You don't have to worry about it. Lawyers are great at remembering to plan in advance. So just remember to charge every day. You don't have to worry about it.
I'm going to think about that. I typically drive them until the wheels fall off. So I got some time to go. It's only 4 years old. What would you guys say is one thing people typically misunderstand about what you do?
I'll go first because it came up in this case too. I think the one that I always get the biggest crack out of, and my wife sure does as well, is that we do everything for the money, and we must be in it for the money, and the money. There's not a lot of cases to be in for the money in rural Oklahoma. So that's the one that gets me the most is all for the money. No, actually, we carry a passion for what we do, and if it wasn't for that passion, I'm not sure we could do this, to be honest.
Honestly, it's our biggest discussion most years is we've actually got to make money this year.
Yeah.
We've got to go do some cases and earn something. I think mine is the corruption, the thought that we somehow are able to, if we get a good verdict or if we get a result for our client, that it's because we have found a way to pay off a jury or pay off a judge. Like we're walking around with cash, handing it out to get results. And it's become worse as time's gone on. But, in modern society, it seems like anytime we get a result, it has got to be, corruption. It can't just be the truth prevailed. It's got to be we've done something to corrupt somebody in the process.
Yeah, I certainly agree with that misconception. I tell people all the time, I do personal injury in addition to criminal defense. And the lifestyle I'm able to provide for my family is because of the personal injury work, not necessarily the criminal defense work. But if you ask me what's the most rewarding, it's being able to help people in trouble more than anything.
Well, we're like 80% family law here. We do some personal injury work too, but I do almost exclusively family law. It's gotten to where I've got a couple kind of bigger cases, but most of the time, if we've got a criminal case, Breckin started it. He got it to the point where it's ready to go to trial, and then we joined together and work on stuff, which is a practice we started before we even worked together. We worked on jury trials together before we were even partners. That's kind of how the idea came about, honestly. And so we do a lot of that. But yeah, family law keeps our lights on. And the family law, everybody's angry. Nobody's ever really happy. Everybody's pissed. And so at least with a criminal case at the end, like if you won, you got a release that you just never get in family law. And that's why I'm like, this is way more stressful than I need it to be because it's just never a good bit of closure. And they might be back in 2 weeks.
I got a call earlier today from the chair of LAJ, which is Louisiana Association for Justice. Primarily it focuses on personal injury related law. And he asked me to be the chair of the tech committee. And then he said, "Are you ever afraid doing criminal defense?" I said, "The only time I was really afraid of my clients was when I did family law for 3
Yes.
years."
Listen, I'm telling you, I got people on the other side that I'm just convinced are camped outside of my house most days. So, yeah, it happens.
So what sets you guys apart from other lawyers in your area who do criminal defense?
Criminal defense we take an offensive approach to everything, to every criminal case that comes in. And everyone who comes in to talk to hire us, I explain that to them. Is from the moment you come in, we start working up a case as if we're going to go to trial. It's because my experience has taught me that if you pursue a case like you're going to trial, you're making the other side commit as much as you are. And you find out real fast if that prosecutor is really committed to his case or not. And that's where all the plea deals come from. Our plea deals come from pushing the other side to its extreme, in my opinion.
And also, it's the process we use.
Yes.
I mean, we do a lot of finding a story, really digging in with our clients from the very beginning, because honestly, if we don't have a story that we can work with, we need to know that before we start pushing, because there's a consequence sometimes to pushing things, as almost everything's going to go to trial. And sometimes you get a case that goes to trial that doesn't need to. Mm-hmm. And so it's pushing that. And then, Breckin and I have wildly different approaches to almost everything. And so we have a way of being able to bounce things off. He'll have something he just thinks is genius. I'm like, I think that's the stupidest shit I've ever heard. And so,
and vice versa.
And we've had jury trials where you've prepped a theme, and I'm like, Brecken, they're going to turn that in their opening statement against you and beat you to death with it. That's true. And we kind of work together and come out with something, and I'll be so fixated on some little thing that's not even going to be a piece of evidence. But we've got to figure this out. He's like, no, nobody gives a shit. It's not going to happen.
That's another thing. I will say, not only is Blake my law partner, he's my longest trial partner. We've done lots of trials together, and we've been doing trials with each other longer than by ourselves. So yeah, we've got kind of worked our way into a groove, I think, that works for us. This last trial we'll talk about, but just to give you an idea, we didn't even spend, we prepped together, but we didn't even spend that much time worrying about what the other one was doing, because it's gotten to where we just know. There's always one leader, whoever's the first chair makes the assignments, and then you just trust that your partner's going to do what he needs to do. And that happened in this trial. And
it's good, because when Brecken I just get in, to jump in after he's got all of his stuff together and just give him shit about it for hours, just like that. No, what about? And that's exactly what happened in this case. I think that was part of, you kind of had a theme coming into it, and some of the stuff that stood out to me as important was not even stuff that he had really worked on. Yeah. And we really got to develop it into a trial strategy that I think covered everybody that we could imagine that would see it.
I agree. Yeah.
You guys sound like my partner and I. We tried a case several years back, and we had a young lawyer. He was trying to get some trial experience, and he was working with us, and Harry and I were kind of going back and forth, and he was like, "Hey, y'all calm down." And we both looked at him like, "What are you talking about?" He's like, "Y'all are fussing." He was like, "No, we're not fussing. We're just disagreeing. And at some point we'll come to an agreement, but we don't have to, nor should we always agree with each other."
Right.
So he got it.
Yeah, and our best stuff is when we end up disagreeing, and we have to figure out how to work through it.
Yeah, I know if my argument's not going to impress him, it's not going to impress anyone else.
That's right. So let's talk about this case we're here to talk about. I want you guys to give us an overview of the case.
Okay. Well, it really did start that morning because it was kind of unusual, because I showed up to the office that morning at a little after 8 o'clock, and there was this kid sitting on the couch next to a lady, and he had his head between his knees. And my assistant, Tanya, said he's here and you need to talk to him. So I took him back into the room and into the conference room, and he disclosed to me that, he had just been involved in a shooting. And that's where it really all started, because I said, "Okay, tell me your story." And he told me the story of what happened over the course of the last, about 10 hours or so.
Yeah.
And what it was it actually started with a fight between some teenagers at an apartment complex, most of whom were underage. Our client was just above being of age. being an adult. And this fight occurred like about 2 o'clock in the morning. We got a bunch of drunk teenagers running around, which infuriated Blake. I'm sure he'll tell you
They
about
called
that.
the drinks tweas. They were drinking twisted teas. They called them tweas all the time. I was like, why in the world are you all using this language? I don't even understand what a twee is.
Yeah. And you had adults there, so it was your typical. These are marginalized kids, adults, poor kids on poor part of town, and they got into a fight over our client's girlfriend being upset at an ex-girlfriend. So one carload of kids comes from a town over.
No, they were staying at the.
Yeah,
Came over. They've been there all night drinking
That's right.
tweas.
They came over. They come over, and they have this fight in the courtyard of this apartment complex. And it was a physical fight. Our client, he took some shots. He got jumped, got punched a few times. The girlfriend got punched. There were other boys that showed up with this ex-girlfriend. So it was a big melee. And during this, the ex-girlfriend of our client made the claim that he hit her. And they all left. The crazy thing is cops showed up.
Yeah.
This,
But you forgot that the parents.
you tell because this crazy
Parents are
to Blake.
loose word. The folks that were in charge of watching at least one of these children came down to break the fight up and ends up with a bloody nose himself.
Oh, wow.
Break the fight up. So the police show up, find him as the adult, and he essentially says, "Oh, we don't need anything. We're good."
And the reason that happens is a pretty typical story that you'll find in most towns, which is this is that apartment complex that's in that part of town that the cops don't want to deal with. The folks who live in town, they want to pretend, those people aren't there. It's the poor folks. It's the poor folks and the minorities.
We went to go visit. There's the car that was in the video from the year before, still broken down in the same parking spot. There are 50 cats that like literally scatter as soon as we get there, and then a roving barefooted child
Just
who comes out to see what we're up to while we're looking at the scene with nobody else around. It's just a very neglected area in everything you can think of.
Yeah.
The client is sitting in your office, right? And then something happens while he's telling you guys. It was you, Brecken, that met with him initially, right?
That's right. That's right. He was meeting in actually the same room we're sitting in right now, and he had some injuries from that fight. And I called a nurse practitioner I know, and I was going to have his injuries documented. And I was trying to work with his mom to get him over to this nurse practitioner. In the time I was doing that, apparently, there were law enforcement officers going up and down the street in front of our office as they've been tipped off that the person they were looking for might be in our
We
office.
are like, well, first of all, that somebody charged with a crime would be in our office would not be a surprise. But we are also on the same block as both the police department and City Hall. And so we are very easy to spot when there's a car on the road.
Yeah. And that is what happened. They
Literally, somebody.
they ran her tag, and I walked out this door here, and there's an agent from the OSBI. That's Oklahoma State Bureau of Investigations. That's our state investigation arm. Standing in the office, and he asked for my client by name, Jonathan Riggins. And I asked him if he had a warrant. He told me that he had exigent circumstances, believed in being here, and he was going to arrest him. So he did. He was arrested in this office and taken out of this office.
Before he's taken away, you guys have a full understanding of what actually transpired, right?
I did. I had the opportunity. I had to spend enough time with him. I got the opportunity to hear the entire story. And this is the story that he had at trial. The story never changed, which was that he began communicating with a gentleman named Tyran Williams, who is the stepfather of the ex-girlfriend we talked about. And they were communicating by messenger, which you're going to hear a lot from Blake about here in a minute, I'm sure. And they were communicating by messenger, and Tyran was asking him where he was. And he was telling him kind of where he was. And eventually what happens is Tyran comes to the apartment complex where our client is. And our client was in an apartment that's on the second floor. Okay. So that's where a stairwell comes into this. So he's on the second floor, a corner apartment. And he's actually inside the apartment messaging on his phone, not going outside. He does have a gun, but he doesn't want to go outside. And he was telling me that the reason why is he's telling his girlfriend, he'll beat this guy up and he's not afraid of him, but deep down he's very afraid of him. And the reason he ends up outside is because his girlfriend, who is only 16, is intoxicated. She believes he's outside and she goes busting out that door. And he follows her out with that pistol. And when she goes outside, Tyran, who's parked in the parking lot area, it's not too far away, sees them and starts to go towards the stairwell. As he's going towards the stairwell, she begins going down the stairwell. And as he's coming up, he turns at the bottom of the stairwell, and our client yells out, "Stop, I've got a gun." He yells out, "No talking," and starts coming up the stairwell, knocks her down. According to her, pulls back like he's going to hit her, and that's when the 2 shots are fired.
Wow. So tell me, after hearing his version of events, what were some of the initial doubts and fears you had?
Well, so for me, this was different because I never do we talk to law enforcement, right?
That's right.
100% of the time, right? But
Brecken broke a rule.
I broke a rule. I broke a rule in this case because
it was obvious. It was obvious.
We had self-defense. It was obvious. This kid was in jail. So about 2 days later, we set up a meeting with OSBI, and he gave this recorded statement that actually ended up being played in court. But he gives a recorded statement of exactly what happens and also demonstrated on video how he shot and fired and what happened. And we did that all without any discovery. I had conversation with my client. We talked it out. He understood that what it meant here to tell the truth, and he did.
How long have you been a lawyer, Brecken?
20 years.
In those 20 years, how often have you done that?
How often have I had a client speak to the police? The reason why Blake is laughing is because some people might not know this, but as attorneys, we all have certain cases or certain situations. We just, for personal reasons, we won't take on, right? We won't represent.
Right.
We'll use our discretion and say that's not for me, right? Well, for me, I've been doing this a long time now, 10 years or so? It's been a long time. I do not represent cooperators. So that gives you an idea of how little I have clients talk to the police. I will represent cooperators. If we have a case where somebody wants to cooperate, which happens a lot more in federal cases, I will actually hand that off to Blake, who doesn't have the same issues that I have with that, and he will take it from there. Because I don't think someone should be denied an opportunity. It's just not for me.
So that means you have never allowed a client to give a statement.
Nope.
Because
there's too many ways for it to go wrong. There's too many opportunities for it to go wrong.
I hate that this fed his bias, by the way, because honestly, it's such an obvious case of self-defense that it is one that you should have given the statement. They should have evaluated it, and that should have been it. They latched onto a couple of things that are explainable, but also are not like a basis to deny self-defense. Running away from the scene. We run away from the scene afterwards. The shots, we do have the one in the chin. The other one, it's shoulder, but they keep describing it as being in the back. And he ends up at the bottom of the stairs face down. And so they've developed a scenario where this person who got shot is running away or trying to get away, and then our guy sprints. But, once you had the story, it wasn't that complicated. And the thing is, we didn't know this at the time, but they already had a statement from one of the eyewitnesses who lied to the cops the first time, but then came back while still drunk and told the cops the truth because her mama told her to. And another statement from the girlfriend. So they already had those things to know that that theory was wrong. Yeah, but they had developed it, and it was just there was no getting past it. And in the end, the charge happened. Immediately as soon as he's arrested, he gets charged. So they can't just dismiss a murder one. after they filed it, the day after they file it. So I think they dug themselves. This whole case is about them digging themselves into a hole and then not being able to just get out of it. They made a jury get them out of it.
I put it this way. As I said, I put it this way, Chris. I think if this would have taken place in any other part of town with any other employed white male and not our client in the place where this happened, there'd never been a charge.
I don't know. That's close. I think if he stays and talks to the police, there's not a charge.
Okay.
I think it's scary. I think it's terrifying for him. But we would have told him not to talk. But if he had have stayed, I think that turns out different.
Oh, that's fair.
Blake is very optimistic, and I'm sure it'll be another 20 years before Brecken ever allows a client to.
Never again.
I learned that lesson. I tell people don't talk to the police. I mean, and
can they do that? Do clients have the right not to talk to the police? Because people don't know. A lot of people don't know. So do they have a right to say, I don't want to talk to you, I need a lawyer?
I think where people get confused is those folks who are supposed to be protecting that right manipulated. I try to educate people on this all the time. Is law enforcement officers take an oath to uphold the Constitution first and foremost. But yet, when you interact, what's your most common interaction with law enforcement officers? Getting pulled over in a traffic stop, right? What's the first question a law enforcement officer asks you? Do you know why I pulled you over? Why is that a law enforcement officer doing it? Because they are trained to try to get you to waive your right under the Fifth Amendment not to say anything. So how is it that we have people that are sworn to uphold the Constitution and then try to trick you out of the rights that are in it? That's tough.
The same questions. Can I see your phone while you're at a stop or while you've been detained? Well, yeah, I guess you have no idea that that's an option to just say no to it. And no matter how many times we tell people on these videos or online, like, you don't have to give them your phone. You don't have to give a statement.
That also brings up another question. Are the police allowed to lie to you?
Yes. That's another good point of education, which I constantly am saying, is you have to understand that there's only one category or persons in this country that our Supreme Court has said it can lie and not face either civil or criminal liability. And that's law enforcement. Nobody else, not us, supposedly not the president. But anyway, nobody is supposed to. The law is followed. There's some type of liability there, not for law enforcement.
And there's historically, we've used that authoritarian ability to manipulate truth in order to gain advantage. And any story in history, you go back and look at the Russian gulags, like, they would tell you they had this information, they knew you were a collaborator, they knew this and they knew that, and they were going to have all this other evidence to get you to confess and to agree. I mean, we're doing the same stuff now that they were doing in Soviet Russia, that they were doing in Korea, that they are doing everywhere across the world, just to trick people into doing something that makes a job easier. And it just
call it the Reed technique.
Well, yeah.
That's right. So tell us about some of the evidence, or specifically the problematic evidence that was developed against your client.
So I'll start off and then let Blake take the opening, because the opening, we had two big issues here. And one of them was, how do we get in our client's self-defense and defense of others to get the instruction, right? My biggest concern was, how do we get the self-defense instruction? The defense of others instruction we could get through through the girlfriend as a witness, but I wanted both instructions. And Chris, the easiest way to do that is to put your client on the stand. But Jonathan didn't need to take any stand. He wasn't the type. He wasn't the type of person who needed to be on the stand. We could do it if we had to, but we didn't want to. Blake told you that we've worked together a long time as trial partners. That's where some of that backroom work that he does very well came into play, because we pre-admitted quite a few things that I think the government thought would help them, but it didn't.
Yeah, well, I mean, they didn't have a way to establish our client. One, I mean, they wanted to establish him as the shooter, and they wanted that admission. They wanted his basis and reason for shooting as part of their evidence, but also this recorded statement is our whole defense. I mean, it's the case. We're just telling the story. And yeah, so I mean, I think part of the compromise was we knew there were going to be some things in there that were not super handy for our case, but there were things we were going to address head on in voir dire and an opening statement. And we needed the rest of it. And like I said, we got an agreement to pre-admit his entire statement along with the body cams and all the footage before trial, which let us use it in opening, which made it to where we weren't stuck telling what I think you're going to see. I could say the exhibits are, the evidence is. I'm not telling you what's going to happen. This is what's already in the case that you're going to have to consider, and here's what it is.
And that was with the added advantage in voir dire. We tackled those danger points, those major issues.
Yeah. That's what I want. Let's go there, because I always tell people the case really starts it starts the day he came to your office, but the trial starts in jury selection.
Well, and this is one of those situations where we have just the most gross difference in what the problems were in the case that you could possibly have. Brecken's got, we have a big board. We've got all of our things on the board. Brecken, I come up and he's got his things. We ran away. It's our gun. We've got a neck tattoo of a marijuana leaf. We've got the stuff like that I would say obvious, not in a derogatory way, but the obvious problems in the case. Mm-hmm. And the first thing I said was, yeah, but this kid's girlfriend is 16. Like, I'm a dad. I got 2 daughters. Like, if my 16-year-old's hanging out with a 19-year-old dude and she's drunk, I don't like this guy already. And so we added that on there. And then I was like, and then where are the parents at in this thing? We've got, like, where are we at? We're at the girlfriend's house. Mom's at the house. Mom's boyfriend's at the house. And there are 2 underage teenage girls and this 19-year-old getting drunk on tweas in the house.
Tweas.
And I'm like, that's infuriating to me. And my first thought is, where's the government doing anything to help these people in general? Like, he's got very fact-specific, case-specific things. And then mine are like, as a jury, if I enroll myself as a member of this community, the first thing I think is this whole group of people are kind of irredeemable. Like, why do I care about these people at all?
Yeah, and what we did with that, and what that showed me, and why that was so helpful, is because this kid had been with me for 17 months, so he kind of grows on it. So you don't see all those things as clearly as somebody walking in might see them. Also, so in the time since he got arrested, between then and the trial, he got tattoos in the jail.
Where?
Oh, yeah. Not only are they bad tattoos, he got them on his face.
Yeah,
of course.
And other things, just to kind of bring up about Jonathan, that's so easy not to like, is the way he speaks. He fashioned himself as a gangster. There's all of that. The way he talked, just everything about him, especially in this community, just oozed we wouldn't like him. So the first thing I did in voir dire was to try to get their attention, shock them, and let's deal with this up front. Is I get up. This is after the court's done its voir dire and the state's done theirs, and I introduce myself very quickly, and I tell Jonathan to come up and stand next to me. Have him stand next to me for a minute. I just pause, but didn't say anything. I look at him. I look back at the jury, and I said, "Look at this. Look at this. Look at the turn around. Show him the one on your neck. Go ahead."
I thought he was going to pull his shirt down. Like, look, do you see what he's got? Like, he was.
And I
the jury was shocked.
They were. I said, "Look at that." And I said, "You can go ahead and guess where he got those."
Yeah. Which there have been a motion in limine specifically about us not talking about him being in jail.
But yeah, but introducing him to that, and then working through those danger points, and it really was in our voir dire. Everything was another one-upsmanship.
Yeah.
Once we got them on the story itself.
Yeah, he shot. We shot him. We shot. Well, maybe it was self-defense. Okay, but he was. Yeah. His girlfriend had been drunk, and it was.
No, that's how we introduced.
Like every time they were like, okay, we can maybe see that this is acceptable. They're like, yeah, but how about if we add to it? He kicked a teenage girl earlier that night during a different fight, and it was this guy's stepdaughter.
And this is after you introduce him as, ladies and gentlemen, this is Jonathan Riggins. He's the defendant. He's my client. He's the man who shot and killed Tyran Williams.
So the obvious question here is, how does that help your client, saying he's exposing his flaws and saying these bad things about him?
Because you've got to own him. He is who he is, and if we don't point it out, they're going to look at it and wonder. We've got to find those biases in voir dire. We've got to find out how you're going to react to it, and we've done this in a number of cases where we have shocking facts. We had another murder case we did in a federal trial where it's another one where my client confesses to shooting a guy when the cops walk up unprompted. And we got a jury trial going on. Like, why are we even doing a trial? That's what happened. She did this. And so it's a matter of, one, just getting the shock and awe factor of getting these facts out. But two, they've got to live with them, because if we don't talk about it and they don't speak those things, they don't talk about those things, the more it feels like, it's something you can't talk about, or it's got to be hidden, or you got to be quiet about it, the less we're actually going to approach these important subjects that we've got to deal with. Because the other one that we talked about that was one of the danger points for me was, as a father, I think if my daughter was hit by somebody, I would want to defend my kid. Like, we got to get past that, because we're going to have dads on this jury. And it turns out we had some dads we knew on the jury that had young daughters that I'm like, if somebody hits your girl, regardless of whether she's in the wrong or not, you're going to want to go make sure that young man understands he cannot hit your daughter. That's what you feel like you want to do as a man. So isn't this guy a hero for going there to do that? Like, and our guy's the villain because he shoots the guy who's going to defend his daughter. Yep. Now, that's obviously not all the facts. We just gave out the worst version of that. But that was the goal, just to get them where they could understand and maybe at least think about what they would want to see to be able to justify that action.
There's a school of thought that I don't agree with, but there's a school of thought that when you discuss all these bad things in jury selection, you may poison the panel. What do you guys think about that?
No, it's the opposite. It's the opposite, because it's the best part of this. When you put all that forward and you deal with it, and you deal with it in a discussion, well, now you have a group of people that have accepted these things, right? They don't have to like them. They just have to accept them. So what you've done is you all have decided what truth is, okay? As a group, collectively, you've decided this is truth. So when you get to the end of the case, like in the closing, as I'm standing in front of that jury and I say to them, what happened in this scenario? Put yourself there. If you're at the top of that stairwell, do you pull the trigger? Well, of course you do. And that protection shouldn't just be there for you. It's got to be there for everyone. So we don't just afford this protection to you, John Sisson, or you, police officer, you really great person that doesn't have all these issues. We reserve this for the worst of us. This is meant to protect the worst of us. And they can accept that because, we've accepted the truth, which is there's lots of things about this person we don't like and we don't care for and we turn our nose down on. But at the end of the day, what he did, how do I feel about that? And take away from him. Right. It's what he did.
After jury selection, we go to opening statement. Who goes first in Oklahoma, the state or the defense?
State.
The state or the defense can do an opening statement at the beginning of the trial, or they can hold on to it and do an opening statement with their own case in chief.
Do you ever do that, or do you always do it at the begining?
We talk about it every time.
Every single time. I don't know that we've ever not done it right after, just because, honestly, I think it's just because we're too weak to hold on. Like, at the end of the day, I can't stand the version of facts that they have put forward, and it's impossible for me to sit there and let the jury think that I'm okay with them hearing that without me correcting it. Like, I feel like I've got to get up there and give them what actually occurred so they know what to watch for.
I agree with you guys on that. I always do an opening statement. There's a psychological principle that I learned, primacy and recency, which suggests that we give an opening statement at the beginning. Otherwise, they hear everything from the prosecution before we really tell our side of the story.
Well, in this case, they told a story that was missing huge pieces right? Like they were missing big chunks, and we'd already admitted the chunks that they were missing. So I got to get up an opening. This is as close to argument as you ever get to get. I get to get up an opening and say, we've already admitted this as evidence. They know that that's not what happened. They know that's not the full truth. Here is exactly what you're going to hear. The evidence is going to be because we've already admitted it. And it, I think, kind of set the scene, honestly, for the whole trial.
Take me through it, Blake. Take me through the opening.
So, the opening line was just no talking. That's what Mr. Williams starts with at the bottom of the stairs. And I think it was the theme that we kind of carried through we use that line a whole lot. His whole idea was he was going to find this kid. He's going to beat the fuck out of this kid, and he doesn't want to talk to him. No going back and forth, no arguing. That's what we're going to do. And so I started off kind of telling that story. I actually printed my opening because I'm nervous about missing anything. But literally I go through and just kind of do the timeline. We have the timeline, and then I literally read the text messages. And by the time we get there, we've got, I've set the scene a little bit, where it happened. We've got these text messages, but the whole point of the opening that I made at the end, which I think was pretty useful, was kind of making it real. And we don't do this a lot. It got objected to, but I had done it so fast that they couldn't really stop it. But we got to the end, and instead of just doing that, I said, you have to put yourself in this kid's shoes. Here's how many feet away he is from Mr. Williams when he's at the bottom of the stairs. Here's where Mr. Williams, we agree he was on the stairs, at least this high. And here's the conversation. I was like, and that sounds kind of mundane when you just read it in that voice. Like it's just, these facts on a piece of paper don't sound like very much. And then I backed up and I said, no talking. And I ran up the stairs right at the jury. And I stopped just short where he got shot. And I said, now how does it feel, though? It's not, you don't have time to react. You're not reading it on paper. You're not sitting in a courtroom where you're safe. It's 5 o'clock in the morning. It's dark. This man's hunted you down, and he's coming up the stairs yelling no talking after you told him you had a gun.
I'm going to steal that from you. I got to use that.
I'm just going to tell you, Chris, the best part about putting something in action in an opening when you can, and this demonstrated it, was there's nothing. Like this the opening was the first thing in the morning.
Yeah.
So there's nothing like doing this opening, having this dramatic ending where it ends in action, and then the state of Oklahoma's got to call some perimeter cop.
You just ignore the biggest thing. You have set the scene. This is the whole. This 2 seconds is what matters, and we're going to not ever talk about that 2 seconds in our case in chief. That's the state's position. Like pretend like it doesn't exist, and move on.
That was beautiful. Blake, did you go to TLC as well? Or
I did. Yeah.
So we've all been putting it into action, but the idea of how you did it, I love it because if you just read it and say what happened, it does come off as mundane. Yeah. And then I can imagine at 9:30, 10 o'clock in the morning, some people are still waking up and you start yelling in the courtroom and charge towards them.
I got the tape measure out. I knew exactly how far it was. Like, I'm going to be accurate because I know if I'm not accurate, somebody's going to call me on it.
That's right.
I moved the podium in the courtroom to where the stairwell was, right? So there's like a leg to the stairs that he kind of spins around when he comes up. So I moved that to that. And literally, I kind of had to quietly scoot back and say, so let's put yourself in those shoes. I'm kind of being quiet. And then I stomped probably as loud as I've ever stomped in a courtroom. And I slapped because he hits the girl, right? So I slap and push the girl aside. I'm pushing the podium aside as I'm yelling, no talking, walking quickly toward the jury. And it was terrifying to do. But, and I immediately got objected to. It immediately gets sustained. And I just stood there.
It's too late.
Yeah, this is what happened. They can object all they want to, but they can't deny that this is exactly what occurred. This is where we're at.
My most dramatic moment in the courtroom was the police officer alleged my client gave a confession while sitting in a chair in the hallway, and there was supposedly a camera. There was a camera on the wall that wasn't working, and there was a supply closet full of audio and video, but he decided not to go in there and get it. So I stood in a chair in my closing. It was in closing, and I said, I'm a video camcorder. I could see and hear. They call me the whole truth. And in that closet next to me was my friend. They only call him the truth because he's only an audio recorder, because he can only hear what the truth was. So I say, they didn't give you guys the truth, and they didn't give you the whole truth. And so afterwards, my law partner said the judge looked at him like, what is he doing? And he said he just threw his hands up like, I don't know. Sometimes we got to do that when the moment is right and the facts are right. I say we just go for it.
Yeah, it's hard to get in the mindset of being a scared kid unless something crazy happens that scares you. And I think that's what it took to get that jury to reset.
It got them there. It got them there, and it put them on our story. And that's the most important part about this trial, is from that opening statement, the state of Oklahoma never told a story. So, I got to argue at the end of this trial that they didn't even have a theory. They didn't give you one. I mean, they got nothing. They spent their entire time saying ours wasn't good enough.
Yeah.
And that essentially was their closing. Their closing was a little worse than that. It was a little bit more personal.
Oh, the big say their closing, it gave a little bit better than that.
Yeah,
you're saying worse. I say better.
Let's go through some of their witnesses, the ones you guys thought were important, and how you dealt with them in cross, and then we'll circle back to the closing.
Sure. There's two in particular. One I took, and then one Blake took. Just so you know, there's only 3 eyewitnesses to this entire event. There is our client, there is his girlfriend who's on the stairwell, and then there's a partial eyewitness to some degree, who knows how much. Was the drunk girl who was also there at the apartment. She claims to have come outside. So the first big witness was Blake taking her on, and she's a minor too. And I'll let him take us, but I remember us talking about this was hard to do because what do you do with a minor who's going to take the stand and not tell the truth?
And who I haven't talked to before that.
And
Brecken has done at least some conversation with her. I've never met her, never spoken to her. And we do that a lot, where Brecken's got the relationship, or he's done the examination before, and then I'll do the trial examination because they're kind of prepped for him, or they think they've got him, or they've got me, and then the other one takes it. But yeah, I mean, you're talking about a teenage girl who was in a bad situation, and we had her original statement, we had her recorded confession to the cops that she had lied to the cops the first time, and then we had some notes and statements thereafter. And so I just started off, honestly, my cross-examination, I asked her about a couple statements that were inconsistent because she had made up new stories during her direct.
Yeah.
And not minor new facts. Her new fact was that our client walked down the stairs and kicked this dead man in the head on his way out, which, 1, there's no physical evidence of. 2, she's never testified about before. And when I asked her about it, she says the first time she told it to anybody was the prosecutor the week before. And I was like, well, why do you think they didn't tell us that part of your story? Which drew an objection, obviously. But there's a lot of inconsistencies. But there's also, how do you deal with the kid? I thought she would be kind of vulnerable, and she was livid.
At one point, there was a break that had to be taken. And we put the jury up. And during that break, she had to be refreshed of some things because she got caught fabricating. So she had to be refreshed of some things. And we came back from that break. Yeah,
Well, during the break, she's saying, he's just going to get up here and call me a liar. Fuck him. What the hell's he doing?
Yeah.
Whoa.
In the courtroom while we're watching the video on my computer. I brought my computer over so she could watch it. And she's pissed off. And the DA, to his credit, is like, hey, yes, he's going to say you lied. You just got to answer these questions. And she just could not get that under control. And we could go through the details of it. There's a lot of details that she switches up and just misses. But she confirms Mr. Williams was trying to hit the girl that was on the stairwell. So we got that from her. That was a positive fact. We corrected all the lies.
Oh, she admitted to lying.
And then I asked her at the end, I was like, so you admitted to lying to the police on the scene and you weren't arrested, right? Yes. You've told the jury today that you lied to them while you're testifying and you're not under arrest, right? You were underage drinking. Yes. You were in a fight earlier that night where you hit a girl, you battered someone, and you weren't arrested. Yeah. And I was like, so, okay. And then she was dating one of the family members of the guy who was deceased.
Yeah.
Oh, well, that explains
They're
it.
in he wasn't in the audience, but his whole family's in the audience.
Okay.
So we get to that. I'm like, okay, well, clearly we got a bias. And then I said, has DHS, because this is again what hit me when I heard, I was like, has DHS been involved with you at all? Department of Human Services? Has somebody come to help you? Why? Why would I need help? Well, you witnessed a murder. You were drunk at a friend's house at 5:00 in the morning, and nobody from the state's offered to help you at all. All they've done is put you on the stand to make you tell lies to us.
That during that exchange, I was watching the jury, and that elicited a reaction from the jury in mass.
Because honestly, I mean, you felt sorry for her. I mean, she's in a bad situation, and they've just enabled the bad behavior so that they can protect a witness to facts that they made up at trial.
Yeah.
I mean, it was a tragic thing for that kid. I'm sure she still hasn't gotten any help, but I mean, that was part of the issue with that witness as a whole.
And the things that she brought to offer were all aggravating. They were
Yes.
like the kicking in the head. She testified that he made statements.
That he just
about
wanted to shoot that motherfucker.
Yeah,
That's all he
things
wanted
like
to do was just shoot that motherfucker.
It was intentionally aggravating. It was also not anything we had seen. It was fabricated.
Yeah.
And that's at the very beginning of the trial. And it's also the only non-law enforcement witness the state's going to offer.
Yeah.
I know one issue you guys probably were concerned with was the allegation that your client shot him in the back. And I'd imagine they call an expert to support that position. So tell me about that.
You'd think they'd call a reconstruction expert, but they didn't do that. But they did call an ME
Yeah, they called
who
me.
had some kind of theories, and that was where Brecken came in. Brecken had experience with this guy. It's one of the few witnesses that, Brecken does the prelim and he does the trial testimony on, because they had such a rapport.
Yep.
This guy just liked testifying. What was it on his socks and his tie?
Yeah.
What did he have? What was it? It was like a design. He had like
Yeah.
it's like a skull and crossbones,
or something like that. Yeah, yeah.
Really?
It was
He was a character.
It was a whole thing. So this medical examiner, I kept trying to convince the state that they didn't want to go to trial with this, and they shouldn't go to trial with this. And one of my last ditch efforts to convince the state of this was after I interviewed the medical examiner, and I spent an afternoon. It was when we were snowed in one day, so I spent a couple hours snowed in. He was snowed in. He's in Tulsa. And we're talking, and we just talked about a few things, and I noticed in his report that Mr. Williams had injuries on his face, abrasions on his face, on his legs, and then some on his stomach, scraping abrasions. Well, this is a metal staircase. And one of the questions was, what's he doing at the bottom of that staircase? Was he shot at the bottom of the staircase? What the state wants to say, or something that would make this not as close to being self-defense. So the first thing I established with the medical examiner was how he was shot. The first shot, we say the first shot because we don't know what succession, but most likely goes through the chin. It passes through the chin, doesn't hit any bone. Okay? So down and to the left, right? So through the chin into the neck. And it doesn't exit his body. It's not perforating. It's only perforating at his chin. That likely killed him. The second shot is on the right shoulder. It's back here, high on the right shoulder, above the shoulder blade. That also went in and went into the lungs and could have killed him. So we have two shots that could have killed him. So I asked the medical examiner, how would you explain this? Well, I'm not sure. I don't really do that part. I said, so I offered him some scenarios. I said, he's the person shooting's at an elevated position. Oh yeah, I would agree with that. Down and to the left or to the right, if you're facing. Well, if that first shot goes that direction and it's on that side of the body, would it be unnatural for you to turn that way? No, you could turn that way. And if the next shot is in fast succession, wouldn't it make sense that it's also going in the same direction, down and to the left, and he might have been turning when the second shot occurs? Yeah, I could see that happening. And if he's being shot at a higher position, shooting down, it hits him in the high of the back, well, then it makes sense he'd fall forward, right? Yeah, that makes sense. And he goes, and then the medical examiner is my favorite part because I sent the recording to Blake. He says, and that also would explain the abrasions.
Oh, perfect.
Well, it makes sense if he's got these abrasions where he's got them that he would have, tumbled down the stairs. So it's not likely he was shot where he was at. Less likely, I'd say. So imagine taking and transporting that to the jury trial, and essentially, yeah, a witness for the state of Oklahoma became ours. He was one of our most effective witnesses.
And they also had given us a stipulation before trial started because of where we had the one bit of blood spatter on the third or fourth step.
Yeah.
That he was at least 3 or 4 steps up on a 12-step staircase when he was shot anyway. So we had him 3 or 4 steps up, between 12 steps and 4 steps up is where we're at. And he has to be able to fall down to scrape. So when we're in closing, this guy's giving us, if he's 6 foot tall, to be able to scrape his whole body, he's going to have to be at least 6 steps up because he had to be able to land on the stairs to fall. So when we kept getting him through the scientific evidence of their witnesses closer and closer.
And closer to your client.
Which fits only one story that's presented to the jury.
And becomes a problem in closing argument where I made an ass of myself.
That's true.
We got to hear it. Did you guys call any witnesses?
Yes. We called the girlfriend.
No, we didn't.
Oh, no, we did.
No, we didn't.
We talked about call. I'm so sorry. Yeah.
We had her there.
We prepared her. We subpoenaed her. She's ready to go, and that's the best part. So the last day, this was a very short trial. This was only 3 days, but it was really one because Void kind of a half day, and we started with an opening in the state's entire case on day 2.
Oh, cool.
Yeah. So we got to the end of day 2. Myself and him, Blake and I had decided we're done. That's okay.
Yeah.
But we didn't tell anyone else that, and so everybody prepared for us to come in the next day and call at least our one witness. And we just showed up the next day, rested, and said, "Let's close this thing." So yeah, we ended up not calling that witness because we were able to get the instruction through the witness that Blake cross-examined. So we got the instruction of defense of others through that witness. We didn't have to call the 2 principal persons that were either, she was being defended by him and he was defending himself.
Yeah, ironically, the witness that gives us the self-defense or the defense of others also got an impeachment and inconsistent statement instruction. So we got
great. Thank you. She was great.
Yeah.
I'm assuming, and I don't want to assume, but correct me if I'm wrong. I'm assuming you got the self-defense instruction based on your client's recorded statement that was played and introduced.
Absolutely.
Yep. Yeah, we put that in through the case agent, and I cross-examined the case agent, and in part of my cross-examination, I just played it.
That was our publication. That was the last thing they heard before they went home, if I remember right.
Yeah, it was.
One of the things I tell clients in cases, Brecken, I'm with Blake. First of all, I do LWOP only cases in one of the parishes here, life without parole. So oftentimes I don't get to choose if my clients give a statement or not. So one of the things I tell my clients is that if in the unfortunate event you have given a statement to the police, then the jury gets to hear from you. The jury has already heard from you if your statement is played. So most cases where they do give a statement and it's played by the prosecution, I'm going to advise them against testifying.
Well, we've had trouble, that's true if that statement is a statement against interest. And so it's not a hearsay exception if it's a statement that's in your client's interest. And we got to deal with that in a trial where we desperately needed a statement in, and we got a denial on getting that statement in because most of the statement was a statement in our interest. There were portions of it that were against interest, but the state elected not to play the statement and instead just use evidence and not let the exculpatory statements come in. And that's part of where we're stuck here. I mean, if we don't get the exculpatory statements, we've got to find a way to get those in, and it would have been difficult to do otherwise.
Yeah.
So what typically happens, they want to play a part of it, and I'm always like, well, you got to play it all.
Yeah.
Let's play it all.
Yeah, that's like I said, the case I'm thinking about is exactly what we ran into, and they chose instead to call the officer, let the officer testify about the inculpatory statements and leave out all the exculpatory statements. And we did the best we could on cross-examination, but I mean, it posed a big problem in getting that in.
Yep. Definitely.
So let's tackle closing. The state goes first.
State does go first.
State goes first.
After they argue about us getting a split of closing.
Yeah,
that was a new one.
We split our closings. We start. Well, we've done that a few times now. If it works. You know.
Yeah.
What? Tell us about that, because there's a school of thought that says never split your closing.
And you shouldn't, because it's really a way to really screw up a closing, especially if you're dealing with egos and everything else. I'm just going to say don't do it. I think we're only at a place where we can do it now because we figured this out after a while, and it's worked okay.
Well, and we kind of stay in our lane. I mean,
Yeah.
if I stick with the witnesses that I dealt with or the portion of the case that I have, you do a good job of sticking to yours, and then we'll split up the instructions that are kind of relevant to those pieces. You got to have a pretty consistent theme through those things, or it becomes a problem.
It's the same thing. You got to have a goal. You know, each of you have got to have your own goal that you're wanting to achieve. That you're wanting to do, and then you've got to trust the other person that they're going to manage to do that, and you just focus on what you're doing
and resist all urges to back cleanup.
Oh yeah, resist all urges to do that. In this situation, Blake went first, and he stuck more to getting dealing with the facts and the instructions. Yeah.
Take us through the prosecution's closing first.
So I'm going to sell it because Brecken doesn't like it, and I don't know how much you get to tell about Brecken. How much you want to talk about?
Tell them all.
Brecken's sensitive about some things. He keeps bumping a table. First of all, he's very
Sorry.
sensitive about not bumping a table. Now, Brecken had an experience a few years ago being charged with a crime, one that was about lying to police, essentially. And they, Brecken and police in this town have a relationship that's not great or necessarily healthy for either one of them sometimes, but it exists. They are always at each other. And so one of the things that, you can expect is that if they can find a way to say Brecken's a liar, they're going to do it. And they knew it because they know in part that'll trigger him. And it would. I mean, he did a 6-day, the trial that he did for his misdemeanor case lasted 3 times longer than this murder case. Let's put it that way.
Wow.
So they get up in their closing statement, and I should have taken a bingo card because I said there's going to be 2 things they're going to say. I could guarantee it. He brought a gun to a fist fight, right? That little phrase. They're going to use that, and they're going to say, Brecken, you came up with this story.
Yep.
Like, you went and met with police that you never do, and it was 2 days after the charge, and after you got to meet with your client, and you went and you fed him this self-defense story, and that's why it exists. And sure enough, that was the bulk of the closing. That the story that they heard was all fabricated, that it was all based on things Brecken had come up with because he knew how to do it, which is why, I'm glad we had a gap. I went first in closing. Brecken went second in closing because I think if it had just been that and then Brecken was right up, it may have went a little different, even though you were able to.
It was very passionate, but it would have been more so. That's true.
And so, yeah. So, I mean, I got to go first on closing after that. And again, for what it's worth, of the case that they had left, because it had kind of gotten butchered in the trial phase, that's what it had to be. You had to believe that this kid's story was a fabrication and that we had just cherry-picked evidence to match the fabricated story, and that they had something else, or the overarching theme of this kid just wanted to shoot somebody was really what occurred.
Yeah.
And so the only way you get there is to point out that the story's got to be made up. And so I got to go through, and part of the difficulty that we did have, I literally, again, I printed up my closing statement. Brecken was probably written on a receipt somewhere. But without knowing what their closing was going to be, the first thing that I had on here is a problem that I always run into, which is people just think of lawyers as liars. We're hired guns. And it's, again, I had no idea that's what they were going to close with, but it was on my mind, right? Like, I'm here to try to make things look the best for my client. I'm going to be twisting these things, that I'm going to be looking, so hard for inconsistencies, and we point them out to affect people's credibility, but we're the ones really making all this stuff up. And so I just kept directing them back to the evidence. Go back to the evidence. What are the words they're not using? Because one of the things they did accomplish was they kept out the deceased's text messages.
Yeah.
Because I had those where he says, I'm trying to find that boy. Where does that boy live? When I find him, I'm going to beat the fuck out of him. There's not going to be any talking. I said that those were going to exist in opening statement because I thought we'd get them in, and then we didn't. And so I had to address it right off the bat because I don't want them to think, again, my concern is credibility in the rest of my argument. If you don't believe me now and I lied to you in opening statement, why would you believe this closing statement? I'm wasting my time.
How did you deal with that issue? The fact
I
that
just head on. I said, I told you this was going to happen in opening statement, and it hasn't.
Yeah.
To be fair, you didn't get to see those messages. Now, what I will say is that the state's not going to get up here and tell you that those messages don't exist.
Yeah.
They're not going to tell you that I lied to you. And
they didn't object?
Lied to you because they can't, because they know the truth, and you get to use your common sense as whenever you hear them talk. If you don't hear them saying I made those statements up, you know exactly what happened, and I don't have to tell you anything else. And
I'm using that too, Blake.
listen, I think it worked. It seemed pretty effective, but I mean, the rest of it, the only thing that I'll leave with is on the closing of mine, because it was not that long, but I met Jonathan Riggins, maybe at trial or the day or two before.
Not too long before trial.
Again, Breckin runs this case for 18 months. We're doing trial. I'm working behind the scenes when we get to prep, and then I'm meeting him, and I'm doing a closing statement for this kid that I don't know. But one of the things we got to talk about was his growing up.
Yeah.
And this whole time, I'm thinking of all these ways that I just don't relate to this kid. We're just not on the same wavelength. The shit he says, I don't like. The way he acts, I don't like. The things he does, I don't like. And it makes me scared for, like, me and my kids. But I'm looking at these messages where he's sending these messages to the deceased where he's acting tough, but you can tell he's also scared. And so we start talking about it. And I asked him, I was like, what? I mean, why are you doing that? And one of the stories he talks about is whenever he was a kid, his dad thought he was like kind of gay, kind of effeminate. And one of the things to toughen him up is they would just like put him in a closet, open the door, and punch him until he basically squealed at them to stop, to toughen him up.
Wow, that's terrible.
I was like, man, okay. Like as a guy, I think a lot of people think that I probably talk pretty tough, that I walk a pretty tough walk. But I grew up being abused by my dad, like physically. And so I know what it feels like to want to look tough, but be scared shitless, and not know how to fix that. Because if you look weak, you're going to get hurt more.
Yep.
So you want to look tough, even if you know the pain is coming, because you don't want it to last too long. And so in closing, I tell that story because it's the only way that I can think of to relate to him and explain. They're going to come up there and tell you about these messages where he says, show up at my house, see what happens, show up, come on, let's go. And I'm going to tell you, he's a scared kid who is dealing with this emotional baggage that I hope none of y'all have to deal with. But I can tell you from experience, wanting to look tough and being tough are two very different things. And you can want to look tough and be scared shitless and have your only 2 bullets and the only thing you had to defend yourself from a grown man. And the fact that this is a father figure adds to that. I don't talk shit to my dad today. I'm a grown ass man. Like it's got to, and I don't know if it helped any. It helped me because it helped me understand him.
It helped me understand him, and I'm just hearing it from you guys. Yeah. Let me ask this, Breckin, did you know that the things Blake got out of the client about?
I did know some of them. So that particular story is actually something we did discover in prep for trial. That particular story, I was very well aware of his background. He was a child of the system. His mother had issues with drug abuse and addiction, and he'd been taken into foster homes. He'd been bounced around. So he was definitely a child of the system. And I was aware of, there was a background of abuse, a background of just everything. I mean, he was very marginalized. I mean,
but I don't know that you actually knew how that kind of affected me in thinking
about it. No, that part. No. I and of course I know Blake, but no, I watched Blake connect to Jonathan through that.
So,
that's where we all find our moment where we get into this thing. I watched him get into this thing in the same level that I was in at that.
The reason I asked is hearing Blake say that brought me to my law partner tried a case. I think it was before he was a parent, before he was a father. And I didn't try the case with him. It was 2 young lawyers who were working in our office went to trial with him. And I was like, I guess I'll just stay at the office and do office work. And he came to me one day. He was like, Chris, you're going to have to come to jail with me tonight and try to talk to this client. The client shot and killed his 2-year-old son's mother. She essentially was charging at him with a knife, and he fired some shots and killed her. And he said, look, every time we prep this guy, he sounds like a robot. He says, she charged at me, I retrieved my firearm, and I fired 2 shots. So when we go to the jail that night, the story is not funny, but the reaction of the young lawyers who were in the room was, so we're talking to the guy, and he's giving that mechanical response. And I say, I got it. I literally remember this. We're like in this little cell. It's like 5 of us. But I say, I got it. So I sit down across the table from him, and I reverse roll with his 2-year-old son. And I said, Daddy, why you kill my mama? And the tears started rolling down. And then I made him explain to his 2-year-old son why he felt the need to fire the shot. And I think that I was only able to do that because I wasn't fully engaged and involved in the case on the front end, and I brought a different perspective. And I think the way you guys do it, where typically work it up and Blake comes in later, we all develop tunnel vision if we're there from day one. And there's just things that we see or others that come in later see that helps. And that's why I think that it's brilliant to never fully go solo in a trial.
No. We do from time to time, but yeah, you're right. It's always better. I always prefer to have somebody there with me to help out for those reasons.
Yep.
I mean, I don't trust myself that I can not have tunnel vision.
Brecken's got a client. I mean, this client, he cares about. He's got a lot into. And just reading paper, I can't identify with him. I can't find a way to find common purpose with this kid.
Sure.
And so it was, like I said, it was great. Honestly, I'm the guy in your story that's like, oh shit, I actually have to explain this. Like, I can't be a robot and say these are the jury instructions, these are the facts, the end, find a not guilty. Like, I've at least got to acknowledge that there's some humanity here that was tough. And that's the only other thing in the closing that I did that I think to me mattered, and I don't know if it mattered to anybody else in the courtroom, was the victim's families in the courtroom.
We both addressed them.
And we both talked to him. Yeah. We both say, hey, this is not, you shouldn't be here. He shouldn't have been there, and this shouldn't have happened. None of this is stuff that we want to have happen. But this doesn't fix it by convicting him of something that is a situation that none of them should have been in the first place.
Yeah. And in my portion, I did that too. Only I take a different approach to it, and I brought the personal back.
Let's hear your closing.
It was so Blake sat down. I knew that my integrity had been questioned, so I wanted to deal with that. So where I started is I just started building facts. Okay, so start with a review, and I started with a review of the facts. This is our story. This is it. You've got this story. What's the other story? Reminding, and then also reminding where the burden lies. Okay, and making sure that that's understood. And as I started talking about about the burden, I also started talking about how the state was trying to shift that burden, and they weren't offering a story; they were offering criticism of our story. That's shifting the burden. Not only is that shifting a burden, it's also shifty and underhanded.
I like that.
And that's where I felt like I gained permission from the jury. Or anyway, I felt like it where they gave it to me.
He took permission whether they gave it or not.
I did. And I did. I started pointing to the state. And I got emotional about it. They're accusing me of this. Let's look at the facts. How's it line up? They're accusing me of concocting this. Well, he's in jail? How am I going to concoct this while he's in jail? I mean, just this is not. They're offering you nothing but criticism, and they're not giving you any evidence. And when we're talking about addressing the family, at this point, when I address the family, I don't just address the family and tell them I'm sorry they're there. I feel bad for them. I tell them that they're owed an explanation, because the reason they're here isn't because they're a family member was murdered, it's because those people sitting at that table don't have the courage to tell them the truth. And, really built upon that. I took liberty with that, and I got to the end of that and basically sat down on the truth, that you've got it. You've got the truth. You've heard it. It hasn't been, nobody has offered you anything on the alternative in any way. They've just simply tried to take shots at it, and it's not even our job. Right? So my point was to sit down and also let them know that when that guy gets up and talks again after I'm done, he's still not going to tell you anything. he's still not going to give you
anything he tells you that's new.
Yeah.
He's only telling you something different and new than anything else in the trial because he knows I can't get back up.
Because I can't stand up.
Yeah.
And I always say this to a jury. Says, imagine yourself, because y'all been paying attention to me, and I appreciate it. But imagine yourself. What would Breckin say? Because he'd probably have a lot to say about what that guy just tried to tell us. And let them understand that nothing that's going to happen is going to change the fact that the state had a burden. They didn't meet their burden. And our client needs to go home. That's pretty much it.
Then the rebuttal.
Then the rebuttal. The rebuttal from the state.
The state gets up and uses the exact language I said they were going to use. They're not going to tell you I lied. They're going to say, it's not an evidence that this message was ever sent. I told them that's what they're going to say. And they get up and no shit say, those text messages were never admitted as evidence.
I mean, so they exist, but
yes.
A big circle around it.
And then the state, and I should not have gotten like this. I just got indignant. But he said, yeah, and he was only on the third or fourth step. The expert testified that he was 8 to 10 feet away. And I was like, no, he didn't. The judge was like, what? I was like, I'm sorry. Objection. Assumes facts, not an evidence. He's lying to the jury about where this guy was when he was shot because we all heard the evidence. He was within 3 or 4 steps.
You said that during their rebuttal?
Courtroom.
Ah.
It was a bad move. I mean, it worked. I said it. It was what it was. But they were so desperate to make a story, and then they just misquoted their own witness. Room after the case, but
it closed.
He did change it. He did correct himself afterwards.
He did.
To what exactly I told him what the truth was. So.
Yeah. And that essentially is how this began, which is we started telling this story in voir dire. We started talking about scenarios and hypotheticals that matched the facts to this in voir dire. And then we carried it through opening. We carried it through each witness that the state put up, and we just finished it and closed. And at the end of the day, I looked at this trial as pretty complete because I didn't see where we left anything on the floor.
Yeah.
Take me through the moment as you guys are waiting for the verdict. What's going through your mind? What's your, as well as your client's, feelings and emotional mindset?
We did get a question, which I loved. We had pointed out, Brecken had held up his binder and said, the OSBI did any of it.
No.
You get to wonder why. You get to use your common sense to figure out why they're not using any of that. And so the first question we get back from the jury was, can we look at the OSBI folder?
Yeah.
I told Judge we just let him, but that did not go over well.
No, and for me, I don't know. It's the part I don't want anything to do with. Actually, I'll say this. You know what I think about mostly when I'm sitting there waiting on a verdict is if there's any excuse I can come up with so I can leave and don't have to sit here and wait on a verdict. That's honest truth. It never works. I sit through every one of them, but I wish I could think of something good enough that I could just leave.
That's usually our role. You get your headphones on and you get out. I sit and kind of wait with folks.
I wish somebody would just call me later, but we don't. So, and then we sat in there with our client, try to find things to talk about or whatever. But we waited for this one. It was a little over an hour.
Yeah,
a little over an hour. So not too long.
Tell me about this picture.
That exploded the whole damn internet.
Boy, that got some feedback. So, the picture's been described as many things.
He's 21, right? Our client is 21.
Whatever.
If I remember correctly. He's old enough to hold a cigar.
I don't care. This picture is us celebrating someone getting away with murder. So, I have a tradition. I've always had a tradition. I smoke a cigar after a trial. And it's a not guilty verdict. Sometimes I'll take a selfie and send it to the DA. That's not the point, though.
I gotta use that.
Well, I like to enjoy a cigar, right? So a couple of years ago, or now, or whatever it's been, I was in. There's a place in Tulsa, great guy. I'm gonna go ahead and it's Pronto Uno in Tulsa, great cigar maker. He makes us a custom cigar. Blake and I sat on his porch and smoked different leaves and things and created
We smoked different tobacco
leaves
Okay.
and created this cigar, this blend. And I have a humidor full of them. So we hand them out, and they're called Wagner Lynch Not Guilties. That's the name of the cigar. And when we have a good verdict, we give them to a client.
And it's to be clear, it is every client that gets a not guilty or we get a dismissal at a jury trial sounding. Usually,
Sure.
We give them a cigar, we take a picture, we post
Every
the story.
time. Because
this one just happened to incite 180,000 page views, literally, and I don't know, something like 500 or 600 comments, and a broad discussion about our corruption and ability to enable a youth to be a delinquent.
I don't think people realize that small firms don't have enough money to be corrupt. Like the things they think we might do, we can't even afford to do those things. So what did this case teach you guys?
Wait a day before you post a not guilty verdict. I think 24 hours. I think 24 hours is reasonable.
See, Blake, I got to disagree with you because I have had jury trials where the media...
Don't encourage him.
I've had jury trials where the media is there every single day. And then when there's a not guilty verdict, there's no media in sight.
That's true. That's true.
That's why we do it.
Part of why we have this tradition because of that. Because we used to chase the paper down. We had a guy who worked local beat, and we would make sure that we called him after a verdict and made sure that he ran something on that verdict. And he's not here with us anymore. Yeah. So we don't get that. So now you're right. We get the PC affidavit. We get the jailbird's picture. We get the jury trial has started and the vicious murder of this person. And then nothing if it isn't a guilty verdict.
That's unfair. That's unfair. I mean, at a basic level, it's unfair to the person who's been drugged through the ringer for several years.
But it also speaks to what we'll do. I mean, as people, what we'll spend money on, what we'll watch. I mean, we love watching someone get caught doing something bad. We love to watch someone in the ringer. And, we don't like whenever it turns out we were wrong to cheer this guy going to the chair or whatever.
And I'll say this, Chris, what this picture means to me is what it really represents. It's not a celebration of any of the acts that occurred in this. It's not even a celebration of the end of a trial, in my opinion. What that is, what you see in that kid spent 17 months in a county jail. He's a kid. He is absolutely a kid. He's, 120 pounds soaking wet when he went in. He's maybe got fat off bologna a little bit while he was in there. Over the course of that 17 months, I told this story a few times. It didn't get told in trial, and it hasn't been told to the people who have an issue with that photo. But that young man had his jaw broken and had to be wired shut because of fights in the jail, because of inmates in the jail that were either relatives or associated with the decedent. Older persons in that jail forced him into gladiator style fights with other inmates, because of his age, because of who he is. I mean, he spent 17 months in that hell. And that picture right there is taken within 30 minutes of him walking out of that hell after 17 months. And the reason he's smiling is because he knows he ain't going back there. And that's what that's about. And it's not about the life that's lost. It's not about the family that lost a life. It's about the life that does get to continue. It's not about winning anything. Jonathan Riggins didn't win a damn thing. He spent 17 months going through hell. And at the end of that 17 months, he won just getting to go home.
Not going home.
Yeah.
He got to run for his life to somewhere else because everybody that was after him. And the thing about this picture that I've known this kid now for 5 days in this picture. And he hugged me 10 times in this room. And I think part of it was just, I finally saw him he finally understood that I wasn't just somebody that was showing up to do work and didn't really care about him, but I actually kind of identified with him. And I think he knew we both genuinely cared that he was well and that he got to go do something. Like, I think for maybe the first time in a long time, he really felt like people cared enough about him to want him to be able to be okay and to be well and to celebrate him, not just root him on, ridicule him, try to get him to do something, but to celebrate the fact that he's got a life and he gets to move on, and he just encouraged him to do better. And it, honestly, I think that's what he was missing with the father figure. That's what he was missing with 17 months in jail. That's what he was missing that night whenever he thought he was going to get the shit beat out of him by a guy that he kind of saw as a father figure at one point in his life.
Yeah.
I'm glad you guys came on. It's 6 o'clock on a Wednesday, and I know you guys have at least two more days of work this week, so I certainly appreciate it. But more importantly, the people out there, if they need you guys, need your services, what part of the state do you work in, and how do they find you?
You can find us at Wagner and Lynch. You can find us on Facebook. Our Facebook page is pretty popular. We've got quite a few people that follow us there, about 8,000 actually, which is pretty impressive for a small little law firm. So you can find us on Facebook at Wagner and Lynch. You can also find our website at www.seoklaw.com, seoklaw.com. And we practice all over the state of Oklahoma, far and wide. And
sometimes outside of there.
Sometimes, yeah, you can.
Excited.
Sometimes Pro Hawk is in somewhere else. So we've got a pretty extensive practice, and just reach out to us and ask us a question. We'll try to help. If we can't help, well, we've got some great friends all over the place like yourself, Chris.
Thank you. I appreciate that. All right. Well, once again, I appreciate you guys coming on, and I'm sure there'll be more verdicts. I'll be stalking your Facebook page like the 8,000 other people to see when I can pull you guys back in. I just think it's important for the public to hear about these not guilty verdicts, because there are so many people who are arrested and prosecuted and they're actually innocent. They have a real true story of innocence, and those are the stories that go untold. True crime is never about the guy who exercises his constitutional right to trial and is found not guilty. And those stories are just as important, because otherwise, if we don't already, we'd live in a police state.
You're going to get Brecken riled up again. Don't do it. Don't do it.
I feel a soapbox coming.
Yeah. But
it's good to see you, Chris.
You too, man. You guys take care.
My best to Harry.
All right, we'll do. Take care.